Hi, Gary DeWaal here, and this is Bridging the Week for March 17th to 21st, and today is March 24th, 2014. Good morning and happy spring. The Commodity Futures Trading Commission again warned the financial services industry how broadly it construes and is willing to apply its new anti-manipulative and anti-fraud authority when it brought and used these new provisions in an enforcement action against an employee of an introducing broker who engaged in unauthorized trading of two customers' accounts and endeavored to hide his activities from the customers and his employer. This is a very worrisome development. But this is just one of many developments I'm covering this week on Bridging the Week, so let's get started. As I said, in another strong statement of how broadly the CFTC's Division of Enforcement may employ its newly gotten anti-manipulation and anti-fraud authority under Dodd-Frank, the Commission filed a lawsuit last week against an employee of an introducing broker who engaged in unauthorized trading in two clients' accounts, as well as endeavored to conceal the illicit trading from the customers, as well as the IB's principals. The CFTC relied on traditional fraud charges in bringing this action, but also threw in its new anti-manipulation authority for good measure too. According to the CFTC's complaint filed in a federal district court in Ohio, Bradley Miklovich, an associated person of Rice Investment Company, a guaranteed introducing broker, traded without authorization through three customer accounts of one customer and the single account of another customer from July 23rd through 30th last year. Because during this time, Mr. Miklovich temporarily assumed certain reconciliation functions on behalf of an employee on vacation who ordinarily performed these tasks, he allegedly was able to falsify both the reconciliations viewed by Rice's principals as well as daily account summary viewed by one of Rice's customers. Rice did not become aware of Mr. Miklovich's unauthorized trades, according to the complaint, until the morning of July 31st, 2013, when it was advised by the Futures Commission merchant carrying the relevant accounts that one of Rice's customers required additional margin or would be liquidated. In response, the CFTC charged Mr. Miklovich with fraud, unauthorized trading, and making false statements under traditional anti-fraud provisions of the Commodity Exchange Act and CFTC regulations. However, the agency also charged Mr. Miklovich under its newly gotten anti-manipulation authority under Dodd-Frank, as well as its recently adopted anti-manipulation and anti-fraud rule. This new rule prohibits any person from intentionally or recklessly engaging in deceptive or manipulative practices in connection with swaps, cash commodity contracts, or regulated futures or related options contracts, without regard to price or market effect. The CFTC did not charge either the introducing broker who paid its guaranteeing FCM the majority of its customer losses, or its guaranteeing FCM in connection with this matter. The industry can only hope that the CFTC's Division of Enforcement uses these powerful provisions judiciously and considers to provide sufficient guidance so that the industry can understand today what might now be considered manipulation other than applying a standard, to quote Justice Potter Stewart in a famous U.S. Supreme Court case dealing with obscenity, quote unquote, I know it when I see it. That was in Jacobellis versus Ohio in 1964, in case you want to look it up. The UK Financial Conduct Authority banned and fined Mark Stevenson, a former bond trader with Credit Suisse Securities Europe, for attempting to manipulate a United Kingdom government bond on October 10, 2011, to take advantage of anticipated quantitative easing purchases by the Bank of England. Between 9 a.m. and 2:30 p.m., or as they say in the UK, 14:30, on that day, Mr. Stevenson allegedly purchased 92% of the value of all of a certain illiquid government bond issue that traded during that time. This amount represented 2,700% of the average daily volume traded in the relevant issue during the private 4 months. He then offered to sell 850 million Great British pounds of the bond, including the amount he bought earlier that day, to the Bank of England later that afternoon at an inflated price influenced by his earlier purchases. The bank ended up not buying the bond that day, quote-unquote, following significant changes in its yield in the run-up to the auction. The Financial Conduct Authority charged Mr. Stevenson with violations of its market abuse prohibition. He consented to the sanctions. On Friday last week, the CFTC extended until May 14, 2014, swap execution facilities registration requirements for certain EU-regulated multilateral trading facilities that effectuate swaps for U.S. persons. Such trading facilities previously had been granted a temporary exemption from registration through 11:59 p.m. on March 24th, in order to comply with certain conditions to obtain a longer-term exemption from registration. The CFTC claims that such an extension is warranted because it soon will issue long-term relief that will track the previously granted conditional relief, quote, but will contain several notable clarifications and amended conditions for qualifying for such conditional relief, end of quote. Can't wait to see the new conditions. Just a few weeks after it and the District Attorney of Manhattan initiated proceedings against lawyers and financial personnel formerly associated with a highly regarded law firm that is now defunct, related to alleged accounting fraud, the Securities and Exchange Commission filed a lawsuit in a federal court in New Jersey against the managing clerk at another well-regarded law firm and a stockbroker related to insider trading. In this new unrelated matter, the SEC claims that Stephen Metro, a managing clerk at Simpson Thacher, on at least 13 occasions since 2009, passed along material non-public information related to pending mergers, acquisitions, or tender offers he learned through his employment to a middleman. The middleman allegedly passed along the information to Vladimir Eidelman, who is a registered representative with Oppenheimer & Co. through September 2012, and is currently registered with Morgan Stanley. Both the middleman and Mr. Eidelman claim the SEC traded for their own benefit using the inside information on most occasions. Mr. Metro graduated from law school, but is not a practicing attorney, according to the SEC's complaint. According to the Commission, in a rendition that appears made for film, quote, the middleman typically passed the information to Eidelman by showing him a post-it note or napkin on which the middleman wrote the stock ticker symbol of the company to be acquired. The middleman then chewed up and sometimes ate, with Eidelman watching, the post-it note or napkin to destroy evidence of the tip, end of quote. Lights, action, camera, for sure. On the same day as the SEC's action, the U.S. Attorney's Office for the District of New Jersey announced the arrest of and that criminal charges were filed against Mr. Metro and Mr. Eidelman related to this matter. IceClear Credit submitted to both the CFTC and the SEC proposed rule amendments to permit its clearing members to use a so-called LSOC with excess model. Under this model, clearing members may transfer to ICC customers' excess collateral not required to meet their initial margin requirements related to their cleared swaps positions. Separately, IceClear Europe filed with the SEC proposed rule changes to address possible losses to IceClear Europe arising other than from clearing member default, including general business risk, investment and custody risk, and operational risk. And finally, last week, David Kotz, a NYMEX member, New York Mercantile Exchange that is, agreed to a modest fine and to disgorge trading profits related to its intraday violations of position limits involving the October 2011 Henry Hub natural gas futures contract on September 27, 2011. During that day, at different times, Mr. Kotz exceeded the relevant standard expiration month position limit by 81 contracts and 96 contracts. In an unrelated action, HSBC Bank USA agreed to a fine of $40,000 related to its entry in 3 exchange of futures related positions transactions on January 28th and May 30th, 2012, where it was on both sides of each transaction. The bank was also charged with not maintaining required documentation related to corresponding cash position in violation of COMEX rules. Both of these matters seem to be part of a purposeful review by CME Group of its intraday position limits and EFRP requirements. as other similar enforcement actions have been filed recently. Check out the article version of Bridging the Week for citations to these other actions and for suggestions to help stay out of trouble. Well, that's it for this week's Bridging the Week. As always, there's more information on each story and more articles on the article version of Bridging the Week on my website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and get outside and enjoy the warmer and longer days. Finally. Ciao.